Welcome to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. In today's video, we'll examine an important legal question. When are daughters not entitled to property rights under Hindu law? We'll analyze three crucial judgments of the Supreme Court of India. 1. Prakash vs. Phulavati, 2016. 2. Danamma vs. Amar, 2018. 3. Vineeta Sharma vs. Rakesh, 2020. Each case will be explained with complete case details, court observations, and practical legal conclusions. Part 1. Legal Backdrop. Hindu Succession Act, Amendment, 2005. The Hindu Succession Act, 1956, was amended on 9 September 2005 to grant daughters equal coparcenary rights in Hindu undivided family (HUF) property, like sons. However, confusion arose regarding the retrospective or prospective application of this amendment, leading to conflicting High Court rulings. The Supreme Court resolved these issues in several landmark cases. Part 2. Case 1. Prakash and ORS versus Fulvati and ORS. Case title: Prakash vs. Fulvati. Citation: 2016 to SCC 36. Court: Supreme Court of India. Date of judgment: 16th October 2015. Bench: Justice Anil R. Dave and Justice A.K. Goyal. Background of the case: Fulvati filed a suit in 1992 for partition and possession of ancestral property. Her father had died in 1988, before the 2005 amendment. The trial court partly allowed her claim. The High Court, applying the 2005 amendment, awarded her equal coparcenary rights. The opposing party, sons, challenged this ruling in the Supreme Court. Issues before the court: 1. Whether the Hindu Succession Amendment Act 2005 applies to cases where the father died before 9 September 2005. 2. Can daughters claim coparcenary rights in such scenarios? Arguments. For appellants, sons, the 2005 amendment is prospective, not retrospective. Since the father died in 1988, the daughter had no surviving coparcenary right on the date the law came into effect. For respondent, daughter, the amendment is beneficial and should apply to pending cases. Daughters should be given equal treatment even if the succession opened earlier. Court's observations: Section 6, as amended, grants coparcenary rights to daughters from the date of the amendment. These rights apply only if the father was alive on 9 September 2005. If the father died before the amendment came into force, no coparcenary right arises for the daughter. Final judgment and key takeaways: The Supreme Court reversed the High Court's judgment and ruled in favor of the sons. Key points of the judgment: The amendment is prospective. Daughter must be alive on 9 September 2005. Father must also be alive on 9 September 2005. If father died earlier, daughter gets no coparcenary right. The right does not revive if it was already lost before the law changed. Impact: thousands of pending cases involving property rights were affected. Daughters whose fathers died before the amendment were excluded from coparcenary claims. Part 3. Case to Danamma at Suman Surpur vs. Amar and ORS. Citation: 2018, 3 SCC 343. Court: Supreme Court of India. Date of judgment: 1st February 2018. Bench: Justice A.K. Sikri and Justice Ashok Bhushan. Background of the case: The property belonged to a joint Hindu family. Danamma, the daughter, was denied partition by her brothers. The father died in 2001, before the 2005 amendment. The brothers argued that she had no right, citing the Prakash vs. Fulvati judgment. Issue before the court: Can a daughter claim coparcenary rights even if the father died before 2005, but the partition happened after the amendment? Court's observations: The court granted equal share to the daughters despite the father's death before 2005. The judgment stated that since the daughter and the property were both in existence, she must get a share. Final judgment and key takeaways. The daughters were declared coparcenaires and given equal shares. Key points of the judgment. Contradicted Prakash versus Phulavati, leading to legal confusion. Held that daughters are coparcenaires by birth, like sons. Focused more on the existence of the daughter and the pending partition than on the father's death date. This judgment was later clarified in Vinita Sharma versus Rakesh Sharma, 2020. Impact. The inconsistency caused further confusion, necessitating a larger bench to clarify the law definitively. Part 4 Case 3 Vineeta Sharma versus Rakesh Sharma and ORS. Case title Vineeta Sharma versus Rakesh Sharma. Citation 2020, 9 SCC 1. Court Supreme Court of India 3-judge bench. Date of judgment 11th August 2020. Bench Justice Arun Mishra, Justice S. Abdul Nazir, and Justice Amar Shah. Background of the case. Conflicting judgments, Prakash versus Fulvati and Danamma versus Amar, led to uncertainty. A 3-judge bench was constituted to settle the law on daughters' coparcenary rights once and for all. Core legal issue. Is the 2005 amendment retrospective, prospective, or retroactive in application? Court's observations. The right of the daughter to be a coparcenar is by birth, not by the date of the father's death. The amendment is retroactive, meaning daughters can claim rights if the partition has not been completed. Even if the father died before 2005, the daughter can inherit, provided the partition was not finalized before 20th December 2004. She was alive on 9th September 2005. Final judgment and key takeaways. The court overruled inconsistencies and laid down the law conclusively. Key points of the judgment. Daughters are coparcenaires by birth. Amendment applies to pending partitions. If partition was finalized before 20th December 2004, no claim. Father's date of death is not relevant if partition was not completed. Daughter must be alive on 9th September 2005. Impact. This judgment restored equal rights and cleared the confusion created by earlier cases. Thousands of women benefited from this verdict. Part 5 Final summary. When daughters will not get property rights. A daughter will not get property rights if 1. Her father died before 9th September 2005 and the partition was completed before 20th December 2004. 2. She has executed a relinquishment or release deed. 3. The property is self-acquired and disposed through a valid will excluding her. 4. The case falls under a different personal law, Muslim-Christian laws. If you are involved in a partition dispute or succession case, consult a competent civil lawyer with all documents. Every case depends on its timeline and property type. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.